So a patent is an exclusive right. We keep hearing exclusive right in intellectual property rights. And for those just tuning in now, exclusive right meaning you own it, you can use it, you can sell it, you can reproduce it. That's what exclusive right means. You can gain the economic benefit for it. So a patent is an exclusive right granted for an invention. This invention can be a product, but it also can be a process. The owner of a patent may prohibit others from using the patented technology. To obtain a right to a patent, technical information about the invention must be disclosed to the patent in the patent application. So once you apply for the patent, you have to make public your entire process, your entire invention. What's the reason for this? The reason behind intellectual property is to continue to invent, to continue for the world to progress. It's not about keeping everything to yourself. It's about having something for, in a case of a patent and in a copyright, for a limited time, and then after that it's for public use. For a patent, it's after 20 years or as soon as you stop paying the fee for the patent. For copyright, for example, it's in St. Martin 50 years after the death of the creator, and that's why you see people can take art from a couple hundred years ago and they can do their variation to it, because then it's free for public use, and that's how the world is evolving and has been evolving. But patent, so in short, what I was saying with that long description is others can then learn from this invention and then they can use this knowledge for new inventions. Can you imagine if somebody had the patent to cure certain illnesses? If somebody could hold the patent for paracetamol for hundreds of years, like if it was like a trademark that you could extend it every 10 years, then we would not have any improvement on that medication. So that's why it's really important to the patent that it's for a limited
when we look
time.
at
The requirements for patents, what can be patented? Inventions susceptible to patents are inventions which are new, are based on an inventive set, and can be applied in the field of industry. So we have novelty, inventive step, and applicable in the field of industry. What's novelty? So novelty is if it's new and is not part of the current state of the art. And state of the art means everything that's made available to the public by means of written or oral expression, by use or in any other way, before the date that you file the patent. Because you get that, right?
Yeah.
Then the inventive step, you cannot claim only the invention is new. That's not enough. It has to be different from what exists in the state of the art. It has to have a technical solution. So it should not be obvious in combination with the elements from the state of the art. So if your patent is clearly a combination of technologies from two earlier patents, your patent may lack the requirement of an inventive step. And then industrial applicability. So an invention is usable in a field of industry it is intended for. So let's take once upon a time you had an ergonomic chair. That was patentable back then. Now you have to really come with...
It will have to be able to fly.
I think so. In order for it to be patentable.